I'm leaving because no matter how much one enjoys a job, there's always a time to move on to the next challenge. I've been doing this job now for 2 to 3 times longer than I ever expected, and while it's been a heck of a ride, always challenging, never boring, I think it's time for me to move on. And I do believe that no matter how good a job one thinks they're doing, there should be kind of a limit that it's good to get, fresh people, fresh ideas to come in, and I think this position's, no different.
Are you being forced out?
Absolutely not. This is something I initiated several months ago, and when I did, I made it clear that I wasn't going to leave the mayor or the city in the lurch, and that included completing the DOJ investigation and helping to deal with at least the immediate aftermath of that, including what the next steps on the road to reform were, and quite frankly, some other unfinished business that I still hope to complete between now and when I leave.
The issue of withholding evidence, concealing evidence, that's something that has dogged the law department under your tenure.
Yes. So the situation you refer to relates to one of 14 divisions, and I think that's important, the Federal Civil Rights Division. I'm not minimizing, and I think to say generally withholding evidence, there was a very highly publicized case where one of our lawyers was found to have deliberately not disclosed the potential existence of some audio tape evidence that turned out to be quite relevant to the case. That is unacceptable. The time it happened, I said, for that to happen even one time is one time too many. And what we did is immediately embark on a proactive effort and initiative to, number one, have an independent third party come in and conduct a thorough review of that division and how it had handled other cases to make sure that this was not part of a pattern or a practice or a culture. Even before that report was finalized and issued, where we had implemented each of those recommendations, plus some more that we had already done, to try to make sure that that kind of problem, that kind of failure to respond, and even if it's not deliberate, just a failure to respond in a timely and fulsome way routinely to discovery would not be repeated.
Be a consent decree.
I don't know that. None of us can know that. What I do know is that the mayor and the police department are committed to reform with or without the Department of Justice, with or without a consent decree. And there's nothing that can or should, and I think there is nothing that will prevent the city and the police department from continuing to make the necessary reforms in the police department.
Donald tape, did you advise the mayor to sit on that tape and conceal it until a judge ordered the city to do so?
That's a matter that the mayor's addressed, I've addressed, and it's been addressed almost ad nauseum. The reason that, well, first of all, as you know from interviewing me on the day that we announced that settlement, and I testified to City Council from the very get-go, the administration said just as soon as that criminal investigation is over, we're going to release that videotape. And that time, for all we knew, that could have been the next week, it could be the next month. As it turned out, unfortunately, that investigation ended up dragging for a long, long time. The reason that videotape was not released, and again, the mayor, I've been clear, and others, is because of a long-standing practice, not limited to Chicago, shared by other governmental entities throughout the country, is not to release evidence that might interfere with the pending criminal investigation. And if there were ever an investigation that one would not want to interfere with, it would be the investigation of this horrific crime.